for your kind words. Ashok Mehta, Harish Kenia, seniors in the profession and dear friends. It's my privilege and honor to be a part of this program, and the chairman has assigned me this task of dealing with this topic of principle of natural justice along with some interpretation of deeds and documents. And I was here yesterday and I could see the introduction, and thereafter Mr. Sunil had dealt with the main aspects of transfer pricing, interpretation, and I hope you all must have understood the basic and the fundamental concepts which are revolving. Though this subject is dry, but it is interesting as it adds some value to you to how to understand law. And over a period of, by the time this course is over, you will also understand how we need to read judgments, how we have to take decisions, and how we can judge a particular situation or particular matter when we are looking from a different perspective. Interpretation is a tool basically to understand the finer points of law. Though the majority who are participants here are from the chartered accountant fraternity, but today chartered accountants also make representation at various forums at various levels. They are able to appear. So to carry out a proper and effective representation, having some basic knowledge of interpretation is must for each professional. And keeping in this view, this whole program was being designed and being organized. Coming to the topic of the day, principle of natural justice. We will have an interactive session. I will be glad to receive your questions at the moment whenever it is there. And I will be putting the questions to you so that you can also answer and how the session can go. I think so the material has been circulated to you. You need not refer that, you just listen to me, and in the course of that something is there, we can have an interactive session. Just to give a brief background, I will just start with some aspects of Constitution, because these all principles comes out from this. See, the Constitution is like a parent from where everything springs up. Any law which has been made by the legislature, if it is not in conformity with our Constitution, it can be challenged. The virus of the law is challenged before the court. The main provisions of articles of the Constitution which might be relevant is Article 14, which talks about equality before law. Now, though this sentence is very small, but it has very different aspects. How equality? If there is a discrimination, we can challenge. If there is a differentiation made which is not based on some reasoning, again the provision can be challenged. Similarly, we have Article 21 which talks about freedom of speech, liberty, which is there. Article 19, freedom, and Article 21 against liberty of a person. So these are some basic provisions of our Constitution which deals and which will revolve around this principle of natural justice. Also, as we are practicing in the tax area, one should also keep Article 265 of the Constitution in back of your mind, which says that no authority can collect a tax or levy a tax unless there is a proper law made or it is under a particular statute. They cannot even take even a single pie from you. So these are some basic fundamentals from the Constitution point of view which one should keep in mind when we are dealing. Also, one should keep in mind this principle is not a right of defense. This is a matter of right. Though over a period of time, and you might have seen few judgments also, where it has been used to get orders quashed. But still, I feel that this is not a right where you can take it as a defense. It is more a matter of right. For example, whenever you try to argue that a principle of natural justice has been violated, It is the first preliminary question which is to be adjudicated by any authority. So if you are arguing a matter and you have a ground to say that something has been violated under the, because natural justice has a various branches, a particular example, cross-examination has not been given. This is a preliminary question which has to be adjudicated. If the court or the tribunal decides this issue, thereafter they may decide whether to send the matter back, whether to give this opportunity, or whether to squash the order, depending upon each facts and circumstances of each case. So it will vary at different statutes, different forums, and at a different level, this will vary. Now, coming further, basically our constitution guarantees three things to each citizen. That is justice, liberty, and equality. So these are the basic stones, cornerstones of our constitution, which we say as the three pillars of our constitution, which cannot be altered, which cannot be amended. It is so sacred that nobody can touch it. And we have three organs in our whole administration of our governing this. There is an executive, there is a legislature, and there is a judiciary. Legislature has to make the law, judiciary has to apply the law, implement it, how it has been functioning, whether the fundamental rights have been violated by the administrator. They have to keep a check and balance on that. And executives are the person who are really administrating that particular provisions of law. Coming to the Indian legal system which is prevailing in our country, the hierarchy you all must be aware. This has been developed over a period of time, and it has some rules, some laws which have been made over a period of time. Though in the past, if you will understand the jurisprudence of development of law, through which today whatever we are seeing, the present scenario has been over a period of time it has been developed. Though the maximum laws which are there are borrowed from the English jurisprudence or the English law. And over a period of time, depending upon the facts and depending on the situation, it has been molded to our situation and our need. But most of the things, if you will find, it has been borrowed from the English law. The topic which we are discussing today, natural justice, actually it is a law which has been coming from the side of administrative law. So if you will talk about something administrative law, there is no act as such saying that about what is it, like torts, law of torts. There is no act about law of torts, but the provisions or the principles of law of torts have been accepted and brought in under the various statutes and law. Similarly, administrative, because we all are dealing with the judicial, quasi-judicial authorities most of the time. The CIT appeals, the assessing officer, most of the functions are quasi-judicial. They are not courts, they are not judicial functions. They are a quasi-judicial function because ultimately they are determining and they are passing the orders. So they are required to follow certain principles laid under the administrative law. And we are dealing today with one of this principle which is called principle of natural justice. To basically understand principle of natural justice in a simple words, it has two basic principles. One is that you hear a person before you decide. So you have to give an opportunity of hearing before you decide anything against the person. Again, it has further branches which I will deal later. And the second is that no one should be the judge of his own cause. So it should not be that I am judging myself or something matters there where I am myself judging the issue which is involved relating to me, which is basically based on the principle of bias. The judge should not be biased. We will deal with some of the provision of Income Tax Act later on, which we will correlate with these principles and how it is there. Because this principle, if you will try to apply under the civil law or under the criminal law, it has a different perspective. But as we are dealing with the taxing statute, we will try to deal with some of the provisions of the Income Tax Act and how it has been applied there, how the judiciary has seen and applied these principles to this our income tax laws. Now this, as I said, that this concept is coming from the administrative law. In simple words, natural justice means a justice which we can get it in a simple manner, which is not complex, which is something universal. So it is also said that it is a rule or it is a principle where God had also followed. When Adam and Eve, they were to be punished, they were asked that why you had eaten that fruit, and thereafter a sentence was passed against them. It was not. So it is always said that it is a law of God. So even God followed this principle. So why not we should follow? And this principle, as over a period of time, had developed. Earlier it was had a very narrow compass, but as the society has changing, the different situations are arriving, the law has also developed in a different manner, and new rights, new requirements as court sees have molded the relief on the basic principle of natural justice. So, some jurists have also said that this principle is something which is mandatory. So, if the Act doesn't provide, still the authority has to follow the principle. Let me ask one question. Can you tell me any provision under the Act, our Income Tax Act, which doesn't provide an opportunity of hearing, but still the courts have brought in that concept and said, no, you should have thrown.
Because that acquisition chapter 26,
yes.
There is a case of C.B. Gautam.
Correct.
Though opportunity was not to be given, but the court
they have asked that. Very good, Sharma. Now I will ask some other provision. Yes, madam, you. Anything you can answer. Any provision which you feel, yes, it was not there. 148. Section 148. Reasons recorded. What the Act requires, a reason is to be recorded and it has to be supplied. But if you will see GK and drive shaft, how it has turned that particular provision and said that no, once the reasons is recorded, you have to provide it. And thereafter not only provide it, but you have to give the SSC an opportunity to file an objection on that reasons recorded. You have to dispose that objection by passing a speaking order. Now again, there was, as I said, opportunity of hearing. Now there is a speaking order. Over a period of time, passing a speaking order is also one of the basic principles of natural justice. So if your order is passed, which is not a speaking order, you can challenge it, saying that the order is not a speaking order, it is a cryptic order, it doesn't lay down the reasons why it is so, and you can challenge this order. If you have closely seen few decisions under 148, when those are challenged, the objections which are challenged before the court of law, the courts have read those objections and said, no, you have not dealt with the objections of the SSC. The reasons which are recorded and the SSC has filed its objection, you have not dealt it in the manner which is required. You have just rejected it by a one-line order saying that it is not proper. They have said, no, this will not be done. They have sent the matter back and they have asked to re-adjudicate those matters. So this is somewhere where the courts interfere and provides this mandatory basic canons of law, a requirement which is required to be fulfilled before an adverse inference is being taken against you by any particular authority. One more example is section 179. A director's liability. It is a requirement that they should issue you a notice and they should pass an order stating why this liability cannot be recovered from the company and why the directors are now responsible for the same, and thereafter they can proceed. The courts have passed so many orders saying that if you do not follow this procedure, the order will not be correct and it may be set aside or it may be squashed. We will come to a issue which comes that whether the principle of natural justice is not followed, whether the order can be straight away said to be bad in law, void, or it is required to be restored back to fulfill this requirement and thereafter proceed with the matter. There are different decisions depending upon facts and situations, and this principle which is there, it is a very broad principle. We cannot try to put it as a formula. In a straight jacket formula, no, if you have not given this, it is bad in law. No, don't try to put this. As I said, don't use it as a right of defense. This is a right which you should ask. If you do not ask, there are consequences which follow. You will find there are decisions which say that fine, natural justice is not followed, but you show me what prejudice has cost to you. If you are not able to show what is the prejudice cost to you, they will say it has been violated because it's no so much bad that I will squash the order or I will set aside the order. So again, you have to maintain this balance. Just it is not a defense that every time you take it and you will find an order in your favor. We will deal with the first principle, the Latin. In Latin, we spell it out something audi alterum patrem, which means that no one should be condemned unheard. The person who has to be affected by a decision has a right to be heard. This doctrine basically focuses on rule of fair hearing. And it changes, it is flexible, its application depends upon the statutory provisions or the nature of the right which may be affected and the consequences which will follow. And therefore its application is always changed depending upon all these factors. Some questions are here, like whether these principles are applicable to administrative authority, whether those bodies are also bound to follow them, and whether this administrative order passed in violation of these principles are ultra vires on the ground. So if you will take up the first question, whether these principles are applicable to administrative authority, the answer is simply yes, it is applicable over a period of time, right from the decision of Maneka Gandhi, where her passport was taken away during that time, and the courts had taken a view, no, if you follow the principle of naturalism, you give a right of hearing. Over a period of time, it has been developed and said that it is applicable to the administrative authority. But this is not something where every time you will believe that yes, it is applicable to everyone. A simple example, you are traveling in a train and you forget to renew your pass. Can you take a plea? No, you don't put me a fine, first give me a principal because today the lecture was there and that speaker had told me so. Can you ask him to do so? So there are places where this may be applicable and there are places where it may not be applicable. Same way in other income tax procedures also. We cannot have it as a universal application that every time something is done you have to give me a hearing. It depends upon the statute, it depends upon the provision, it depends upon the rights, it depends upon what is the consequences which will be following, and thereafter this it can be claimed as a right. Because you should be aware that though this law is very sacred, this principle is very sacred and has been brought in for some good purpose, but there are occasions where these principles are misused to delay the matter, to get unwanted benefits. They will not take a plea that I have not received the document at the time of assessment, but in the appellate stage they will take this plea and they will say, no, see, you have not given me this statement, you have not given me this copy, and therefore this order is bad. No, you cannot use this. You have a right, exercise that right at the first available opportunity. It is up to the appellate authority to judge and to balance that yes, if the SSC by some reason has not raised this, can it be given? Can it be given a second chance? But that is a different aspect. But this right has to be exercised at the first available opportunity. The moment you get this, if 148 notice has been issued, you have a right to ask for the reasons. If you fail, you cannot come at the appellate stage and thereafter say, look, you had issued a notice but you have not provided me a copy of the reasons. The question will be asked that whether you had asked so. If you have not, you cannot take up this defense at a later stage.
It is always necessary that you should ask for it.
According to me,
opportunity to cross-examine.
Yes.
Suppose some party has given some statement and we don't ask for the cross-examination, then later on can we say?
See, again, as I said, it depends upon the facts and situation. If you have been aware, for example, in the course of an assessment, a show cause notice has been issued that there is a statement which has been made against you or your client, and on the basis I want to make a particular additions or disallowances. At that time you choose to remain silent, though you are aware about this statement, and you at the appellate stage when you will raise this plea, it may be that the appellate authority will refuse to give. Or he may direct that, yes, fine, your rights have been violated, I understand, maybe because of some technical reasons or because of ignorance of law or something, you might have not raised this plea. Take this statement. But I am not going to send the matter back now. You take this opportunity now, plead it whatever you want to plead it. I may not give you a cross-examination, take this statement and now you go further. Unless you show some substance in the matter. For example, in my short career, I have also tried at the second level stage, at the tribunal level, that to show that why that statement is bad in law. But how we have done it? We have done it by producing some fresh evidence before the appellate authority and try to show them that, look, yes, I had whatever rights were there, whatever grounds were there, I have not taken earlier. But now at least I have put something on the record which shows that the earlier statement or the earlier documents which were found is contrary to the facts on record. And therefore now the judges have to weigh both the things, what I have produced for the first time and what the assessing officer had recorded at the time of assessment. And maybe at that time we plead that this discretion should lean in my favor and the matter may be restored back to have weight of both the evidence and thereafter to decide the matter. So this is somewhat we have to make. So that is a different art altogether. So this is as I said in the beginning, this is a principle, use it, but don't use it as a tool of a defense. It is your right. You should be knowing that when and how it should be exercised.
Generally, cross-examination will not be allowed at appellate.
According to me, if we have not pleaded, it is difficult to allow unless you have something to show that at that time this was the circumstances and now it is it. For example, the person, you get an affidavit at the later stage and you file it and you show that the statement what he had given earlier and the statement what he had given to me are contrary to each other. At that time, the appellate authority in their exercise of their discretion may lean in your favor and they may set aside the matter to comply to the principle of natural justice. But you simply go and say that, sir, now I want to cross-examine. Maybe they may not follow.
No, Ajay, if they don't give you the statement, then that's bad enough. Just giving me a show cause notice that I have recorded a statement of this nature from someone from the unit has recorded.
Yeah, I will come to that, but I will just answer for the moment, but I will deal with that in detail. The basic principle of one of the principle of natural justice is also that a person should be put on notice. So I should know the case, what I have to meet when I have to appear before the authority. So if there is a statement, the statement should form a part of the show cause notice, which we normally see it is not being done. So what is required? We have to ask for it. We have to demand it so that I can make a proper representation. Still they don't give, then the matter is in your favor. Then it will lean in more in your favor. The other rights are obviously there, you can apply under the RTI and all that, but these are different things. But there is the first requirement that you should demand it. Though it is a requirement that along with the show cause notice, it should go. It should go. That is one violation done by them. But you don't violate it or don't rely on their mistake. You don't commit your mistake. You demand it. So the requirement is that you should demand. So there are decisions now which says that this principle of natural justice now applies to both judicial as well as administrative authorities, and therefore it is required to be followed. The assessing officer should also observe this principle of natural justice while making an assessment. Earlier there was some dispute or there might be some confusion, but now it is well settled principle that this principle is required to be followed by the assessing officer in the course when he is dealing with your assessment. You can refer to the Supreme Court decision on 26 ITR 775. All these citations are there in my notes. Don't bother to. If something is not there, I will let you know. Everything is there. You can read at leisure this article which I had just expanded it because therefore it has gone a little big. You can read at your leisure. Similarly, the Supreme Court again have laid down the same principle by saying that if this right of natural justice has been violated at the lower stage, we cannot, by giving this, complying this at a later stage, at the appellate stage, will not serve the purpose. So, if 140 is the reasons recorded has not been given to you at the assessment level before passing of the assessment order, when you are at the appellate stage, at that stage they give you, take fine, you are complaining about the reasons recorded, now you can take this reason. Don't complain that you have not been given, you are well aware, you take the copy now. Whether it will be fine, whether it will be a compliance, the answer is no. Something which was required to be done at that stage has to be done there. You cannot comply with it at a later stage and say that I have complied with that principle, which will not. In the case of Tin Box 249 ITR 216, Supreme Court has laid down this principle that lack of opportunity before the AO cannot be rectified by the appellate authority by giving such opportunity. Similarly, as we had taken the example of reassessment, reopening, there are direct decisions of Mumbai Tribunal as well as Bombay High Court in the case of Tata International and CIT versus Videsh Sanchar, where the courts have taken a view that a reassessment which is completed without furnishing the reasons actually recorded by the AO for reopening is not sustainable. Just to give a brief background about this case was that they had actually given the reasons, but that reasons were not complete. So they had given some small para of reasons recorded, the actual reasons which were recorded in the records of the assessing officer. The SSC had challenged, had questioned that you have not given me the complete reasons, which it took the matter up to the tribunal. The tribunal held that what is required by the law is that you have to give the complete reasons recorded. You cannot provide half of the reasons, you cannot provide one part of the reasons and say that I have tried to comply. The requirement of the law is that you have to provide the complete reasons to the assessing officer, to the SSC. If it has not been done, you can challenge it. So the Tata International Mumbai Tribunal has dealt with this issue, and also it has followed the decision of Videsh Sanchar Nigam Limited, which is of Bombay High Court, reported in 340 ITR page 66. So in case the reasons recorded are not proper, you can challenge that. I had a very peculiar case, it is though it is not, I have not referred, where the copy of the reasons were not provided to the SSC. Again, the extract of the reasons were provided, and in the assessment order, what was extracted and what was provided to me had a different, some paragraph, some language of the, though the substance of the reasons was same, but the language of the reasons recorded were a bit different. At the appellate stage, we took a plea that the reasons which has been provided to us and the reasons which has been extracted in the assessment order is quite different. And though the substance is same, but what is required is the reasons what has to be provided. It cannot be substituted, it cannot be, some words cannot be added, it cannot be altered. That is what the law requirement or the law is there. The court called, the tribunal called the records, and they found there is no reasons recorded actually in the file of the AO. And thereafter the matter proceeded, and thereafter affidavit was asked, directed to be filed by the assessing officer, and the assessing officer filed an affidavit stating that the reasons recorded is actually in the computer and he forgot to take a printout and keep it in the file. And he said that it should be accepted because it is in the computer, and he gave some screenshots of the computer along with the affidavit, and he filed that affidavit. We also filed a counter, and in the course of the argument they said that it is on the record and the computer is also a record and part of the proceeding, you cannot deny it. So the members are that if we will accept this plea, tomorrow it may happen that you may say that I have recorded the reason in a diary which is kept with us. Or they say that you will tomorrow you may come and say that it is recorded in my mind, in my heart. I have forgotten to spell it out on the paper. So they have rejected this argument, though there was an affidavit and everything was filed. And they have not accepted this. So there are situations, and we have to also mold our relief and take the plea according to the facts and the situation of that case. Similarly, there is a decision of Sushila Suresh Malge of Mumbai Tribunal, where the tribunal had directed the assessing officer to provide certain statements which were recorded at the time of assessment. And we had asked all along, right from the assessment stage, and it was one round of litigation which reached to tribunal, and it was an assessment which was made under 158 BC, and at that time it was a direct appeal was provided against the 158 BC order to the tribunal. So one stage of CIT appeal was missing, and we had raised this plea. The tribunal saw that it is a very factual matter. It was about computation of the undisclosed income based on certain documents. It said it's a little complicated, and we will be pleased to set aside the matter back to the AO to provide the statement and material, and thereafter reframe the assessment. In spite of doing that, the assessing officer, the actual fact was the old file was there, it was not there at all, and the assessing officer was not in a position to hand over those materials or the statement. So he preferred to pass the same order and make the same addition. And he passed identical same thing. The matter again came to the tribunal, and tribunal pleaded that you had asked them to provide us the seized material and the statement, which has not been done. And now this is the second round of litigation. Then they had imposed a cost on the assessing officer and asked them that you have to pay a fine because you have not complied to our order. So this is a case, this matter went up to the High Court, but the High Court, for some technical reason, the matter was dismissed. Department's appeal was dismissed, not on merits, was technical reason. So you can find there is this case where the courts have awarded cost, the tribunal has awarded cost on the assessing officer for not complying to their direction. So this is one decision. So as we see that these elements of this principle, basic principle that no man should be unheard, have a different facet within our Income Tax Act. We will go now to each branches of this particular principle, which again have been developed over a period of time, and I can take it as a first right to notice. As just now some question Ashok had raised that they are not providing in spite of referring in the show cause notice. Basically, this notice has come out from a Latin word notia, which means being known. So a person, when he appears before an authority, he should be aware about the charge, what he has to meet before the officer. He should be aware about what is the question which is raised against him, which he is required to answer. What are the details he has, the officer wants, which I have to provide him. It cannot be in air. A best example of this I can give you is the recent Supreme Court decisions where in the case of penalty matters, they have taken a view that when a penalty notice is issued, the assessing officer failed to cancel the two aspect concealment of income or furnishing inaccurate particulars of income. So if you don't cancel either of the item, you are not informing the assessee what charge you have to meet. And thereafter many times it happens that you have cancelled one aspect. For example, you have taken concealment and you have cancelled furnishing inaccurate particulars, but the assessment order is exactly opposite. So the courts have taken a view that look, if you have done something like this, the notice is bad in law. You cannot have a notice of penalty wherein you have not, you at the time of initiation itself you are not sure that what is the charge on the SSC. So this is something which has come up recently and developed. There is a Karnataka High Court decision and there is also a Bombay High Court on the different facts. The Bombay High Court also has followed this.
So in this case, can we say that the notice, or can we generally say that the notice which is technically deficient,
yes,
such a notice does not serve as an opportunity of being heard?
Correct.
Which is technically deficient on any
Correct. So the notice itself is bad in law because nor the officer is aware what is the charge against the SSC, and therefore the SSC is not able to meet his charge against the notice what has been sent to him.
But in the assessment order, if it is mentioned, whether it is concealment or furnishing of eminent, and in the notice he doesn't cancel. But then things will be different.
See, right now there is a decision in your favor.
Yeah.
So don't try to dig it more to get a clarification on this. But to answer your question, the penalty is levied on what basis?
See, there are three aspects. One is the assessment order, one is the notice, and then the penalty order.
Correct. According to me, what the Supreme Court has answered is the notice. Your notice is incorrect, and the court is not seeing that what the basis of issuing the notice. They are saying that the charge what you have to face is not the assessment order. The penalty is not levied because you have initiated in the assessment order. The penalty is, the limitation period, if you will see, starts when the notice is issued. The levy of penalty is on the basis of issuance of the notice. If the notice is not issued, you might have mentioned in the assessment order, the penalty cannot be levied. For levy of a penalty, there is a requirement that you should issue a notice. Maybe the starting point may be the assessment order, but the charge, when you are framing, you are levying a charge on somebody, you issue a notice to him, and that is what is the court had seen in the Supreme Court decision and also by the Karnataka High Court. That say that when you have issued the notice, you have not specified that what is the charge, and therefore they have squashed. Maybe now, as Sharmaji has taken more deeper issue, somebody will try to argue and they will say, no, we will clarify that decision. It is not something like that. So still these are the grey areas, but for the time being, you can take this as that this is the law, and you can take the benefit at the different provisions of the Act.
Can you take a stand that it is on both the counts?
Then the penalty levied should also be on both the counts. Then the penalty order which you have levied, the charge should also be on both the counts. There might be a case, sir, where there are two different amounts which has been added, and one of the amount falls under the head concealment, and one of the amount may fall under furnishing of inaccurate particular. So, as I said, when we are reading a judgment, read what is the facts before the court, and in what context the judgment has been delivered. So, if you are asking that decision on notice was on a peculiar facts, based on that fact they have said. So, if you have a case fitting in that fact, please use that. Don't try to dissect that decision in some other areas which may not really help you. So, the facts was very limited and focused about the notice. So, on that basis, that notice, it had been scored.
Ajay, the penalty, both are mutually exclusive. Inaccurate particulars of income and concealment of income. They are mutually exclusive. So you can't have a situation of the same amount you have both.
No, I am not talking about same. I am talking that there are two different amounts. There are two different amounts.
Sir,
so,
if AO gives you the notice or something like that on his order sheet and takes signature of the
client,
of the authority, like authority holder, that will be a good notice?
Yes, once you have signed, it will be a good notice. If you have signed the order sheet, it will be a good notice. Unless you mention there that yes, I am aware, but kindly issue, if that is the case, you should mention that kindly issue a notice. Thereafter, you write a letter, because many a times, because of these technicalities, some serious consequences may follow on your client. It is always better to allow the officer to issue the notice to the client, and you don't go and accept it. There is a habit when the assessment orders are passed. As a professional, we know the assessing officer, we go and collect the assessment order and sign on behalf of the assessee. We don't understand what are the so many consequences follow on that. Tomorrow, for some reason, the client is not happy with you because there is an addition in the order, and there is some issue of limitation period in filing the appeal. He may ask you who had asked you to collect the order, because the order is required to be served on the assessee and not on the representative. You have cases of 148 where the notice of 148 was handed over and served on the chartered accountant, because the chartered accountant was representing that assessee so many times. So instead of serving on the assessee, they had handed over to the chartered accountant. The matter came up later on, and that whether this service is proper, the courts have said no, this service is not proper. The requirement of law is that the notice has to be served on the SSC. So it is advisable that you should not accept such a notice. You can take a cognizance of this notice, but you should always request that let the notice be served as a usual procedure on the SSC. It is advisable from both the point. Your SSC will be aware that such a notice has come, and the consequences when follow, he will be aware that this is what is happening. Many times it happens that something has happened, and later on, when all these issues arises, they will say that I was not aware, or my chartered accountant had not informed me. So it is always better as a part of representation, let it go to the SSC.
Can notice be corrected?
They have to issue a fresh notice, for example 148. If 148 is bad in law, what they have to, for some reason, technical reason, some assessment here is mentioned wrongly, then they have to issue a fresh notice. Under section 292BB, now service of notice, they have given a limitation under the Act by saying that if you have some doubts or questions regarding the service of notice, you should challenge it at the assessment stage. You cannot challenge it at a later stage. Just because you have raised this point, I will deal it one step further. For example, there are issues where we say that 143(2) notice has not been served, and there is an issue 143(2) notice has not been issued. So these have two different meanings. One is that you have not received the notice, and one is that it is not issued at all from the records of the assessing officer. Many times they fail to issue it, and they issue directly 142(1) notice. And then the courts have taken a view that section 292BB will not come to the rescue. It will be only in the cases where it has been issued but maybe not served in time. In those cases, section 292BB will play, but not in the case where the assessing officer has not issued the notice at all. There is a Gujarat High Court decision directly on this point, dealing with this point in context to 148 matters. So this is something regarding the notice. Basically, it is the person should know about the subject and the issue involved in the case, and he should be in a position to defend himself. The notice, the requirement of a notice is time, place, nature of hearing, the legal authority under which the hearing is to be held, statement of the specific charge that the person has to meet. So this is something about notice. Now the second aspect which is there is right to know the evidence against him. Say as we are dealing about the statement or about some seized material, if something has been relied by the assessing officer in his show cause notice, or while framing the assessment he wants to rely, the copy of the same should be provided to the SSC. Many times it happens that the assessment is completed, and later on in the assessment order we find some material is being referred or some statements are being referred by the assessing officer. And it was never questioned to you in the whole course of the assessment proceeding. You should see that you raise a specific ground in your grounds of appeal and do mention in your statement of fact that this was never confronted to you, and therefore now after the assessment order has been passed you are making this plea, because there it will not, the earlier principle will not apply that you had not asked for it in the course of assessment. You had not asked because you were never confronted with this material. So therefore there this principle will have a different turn, and you can raise this plea by way of your grounds of appeal before the CIT appeal in your statement of facts as well as in your grounds of appeal. It will be advisable that you also file an application after the assessment order is there. It is advisable that you file an application stating that on perusal of the assessment order, it is seen that for making the addition you have relied on some so and so things which was never confronted to you. Kindly provide a copy of the same. This will help you in your appellate stage. So you have to raise a ground, take it in your statement of facts. Also, if you can file an application, it is advisable. Okay. There is a decision of Supreme Court in the case of Natwar Singh Kanwar. Natwar Singh, he was involved in the oil scam, and the matter, the enforcement directorate had framed the charges and all this was there. and all the time in the course of the whole proceedings, he had made applications for getting the seized material from the Enforcement Directorate and other authorities, and this material was not given to him. He took a plea when the matter had started. So he took a plea before the Supreme Court, stating that all the documents which were seized were never provided to him, and therefore the principle of natural justice has been violated. The Supreme Court, after going through the whole matter, they said that it is not a requirement that all and every document which is seized should be provided to you. You have to be very specific, and you have to ask for the relevant document which is being used against you. And what are the documents you require? You cannot just say that I want everything. You have to meet the charge which is framed against you. If you have no, there is a specific document, you have to ask for a specific document. Seeing the peculiar facts, the issue involved, the gravity of the matter, the court has said no, this is just a delaying tactic, and they have dismissed his matter. And he said you better go to before the authorities, when the authorities will go ahead, decide, you ask for the relevant document. Just you don't come here running and trying to delay the whole matter. So you should understand this decision in the context of what was the situation prevailing before the court at that relevant time.
So a document which is incriminatory in nature should
and used against you.
Used against
you. That
provided to the
should be provided. There might be so many things which might be there with the officer, but if he is not using it, you may ask him. That is a different thing. But you cannot challenge it in the court of law saying that it has not been provided. You may ask it for so many reasons, but you cannot challenge it saying that this principle of natural justice has been violated. So, yeah.
In this case of these Kavarlal Jain and all those cases, they are only providing the 2 or 3 paragraphs instead of providing the full statement.
They are providing. I have my few chartered accountants, they are bringing the whole statement.
The entire statement?
The entire statement.
No, but they are saying the relevant portion is this, and therefore would this hit that?
No, you have to, a statement again, if the basic principle you might have seen in the earlier and yesterday, that whenever you are reading any document, forget statement, any document, you have to see the whole document. So you cannot pick and choose one paragraph of the statement because you don't know what is the previous para and what is the later para, what the person might have stated. So it is necessary that though one of the question is against you, but you may require to go through the whole statement, in what context the statement was asked, in what context he was answering, and what are the other questions in the whole proceeding which is. So you should ask for the complete statement, and I think so they are providing.
The section itself, 142(3) section itself will give you the power.
So right to present the case and evidence, it is the same. Now again, right to present the case. So does it mean that in all the cases you should demand a personal hearing? I want a personal hearing in all the matters. So in whatever matter is there, I should get a right of personal hearing. Answer is no, it depends upon again what is the issue involved, what is the statute which is there, whether a personal hearing will if not provided, there will be some prejudice which will be caused to you. Depending upon that situation, this right of presenting case and putting the evidence is to be provided. As far as income tax proceedings are there, and like under 263, whenever show cause notice is issued for issuing of 263, they provide you an opportunity of hearing. When 264 matters are there, then it is provided. So 179 recovery matters are there. Courts have come down heavily on the officers for in stay matters that you should pass a speaking order and hear the SSC before disposing of your stay application. So these are the proceedings where there is an adverse inference might be drawn and adverse order will be there against the SSC. The courts are saying that you should give a personal hearing in the matters. Right to cross-examination, again I have dealt it in my talk, it is the same principle, you should depend, you should ask for it, and the right should be given to the other side to refute the statement or the observation which has been against it. And this has been followed by Supreme Court in Kishan Chand Chelaram, and recently if you will see there is a decision of Bombay High Court in the case of RW Promotions where the courts have dealt with this right to cross-examination which was not provided by the lower authorities, though this plea was taken before the ITAC, but the ITAC also refused to grant this right of cross-examination, and when the matter was before the High Court said that nothing doing, you have to provide it, because the whole basis of addition is the statement, and the SSC all along had demanded this copy of the statement which you have never provided, the cross-examination which you had never provided, and therefore they restored the matter back. And they said that this opportunity has to be provided. So whenever this cross-examination statement is recorded, you should try to see that you raise this plea at the first available opportunity. Don't wait till later on. The moment you find that there is some statement, please raise this plea. You will have a good defense at a later stage. So this is something about cross-examination. Right to a counsel, also normally it is not much applicable. However, for example, many times a question arises that whenever the assessing officer issues you a 131 notice to your client, can I be present in the cabin of the officer? So normally in practice what happens, they allow you, unless you try to poke your nose in between and try to give the answers instead of the SSC answering. So it is more a practical, you don't have a right to counsel in each and every matter. So when a statement is being recorded of your SSC, you cannot claim as a right, no, I should be present there. Yes, you can demand that my client's statements, let me be present, but see that you maintain the distance, you don't try to answer on behalf of the SSC. So you should allow, but you cannot claim as a right that you should be present.
At the time of search and survey also this issue arises.
At the time of search and survey, but normally in search and survey they call the chartered accountant himself to explain the accounts and so and so. So it is normally allowed unless the cases are there where the SSC acts smarts and he tries to dodge the authorities by creating some groups or doing something. In those cases the authority also act in the same manner.
They call, but their view is that it is just a fact-finding thing.
Correct,
So
correct.
not,
Not fact-finding, it is a search.
I know. So
It
we are
is a
just
search, thereafter the fact-finding will follow.
Right. So we are just examining the things and your presence is not required.
Correct.
That's what the case law also
Correct,
says.
correct. And therefore I said you don't demand it as a right, but if you ask it in a normal manner, they may allow you, provided that you don't interfere in their working, because it is an administrative action.
Yeah.
So you cannot demand it as a right to be present. They are not concluding anything.
Yeah, that's it.
Can authorized representative take cross-examination?
Sorry?
Can the authorized representative make cross-examination?
He can take, provided the SSC should be there with you.
Yeah, but
Your SSC should be there with you. So you can take a help. So your question should be, can I take a help of a counsel or a professional person for a private cross-examination? Its answer is certainly, because your SSC is a layman. He is not much equipped to the knowledge of Evidence Act or the cross-examination, and therefore he can certainly take help of the counsel or his representative for the purpose of cross-examination. But he should be present there. Reasoned order, speaking order, the basic rule, one of the basic rule of principle of natural justice is that there has to be a reasoned order. A cryptic order or order which is not supported by reason is no order in eye of law, and it can be squashed, it can be set aside depending upon the facts of the case. There are few decisions which I have listed down. Some are in context to stay matters and others are also. Sometimes the High Court even has squashed the tribunal order on the ground that those orders are not coming out with the proper reasons why such a finding or conclusion has been arrived. So one of the requirement of law is that once you pass an order, it should be a reasoned order and not just a cryptic order. There is a last decision of Saheli Leasing Industries 324 ITR, which gives a detailed guidelines laid down how a judgment has to be written. If youngsters who are sitting here thinking tomorrow they might be sitting in some judiciary position, you have to read this judgment before you write the order. It will be better for us when we present before you. Let's come to the second rule, which says that rule is against bias. So it is basically that no one should be a judge of his own cause. This rule basically revolves around the principle of biased. So if a person is interested in a matter, he should not decide that matter. You might have heard many times, like in the BCCI case, many times the judges rescue themselves for the reason that the party is known to us. Normally the judges in the High Court and Supreme Court are basically counsels who have practiced before the lower authorities, before the court, and somewhere or the other they might have advised that particular client, or they might have represented for that client. So it will not be in their interest to hear his matter before them. So for that reason they rescue themselves. Unless there is a bias, is a normally nobody pleads. One of the famous cases which I recollect is the Vodafone case. After the orders were passed, there was a review petition filed in the Supreme Court by some lawyer, and he had taken some points about that because somebody was related far off, and therefore there was some bias in the matter and some aspects. So that it was quashed, and what I recollect that they had passed some strictures also against that gentleman, saying that this is not something, if that was the case, you should have taken up beforehand. And that was certainly not falling within the meaning of bias or the criteria of bias which was being spelled out. And it was quashed. So one has to be very careful when they are raising this plea, because you are raising this plea against the judge or the particular authority. So you have to be very sure when you raise this plea. Normally we don't find in our tax proceedings this rule to be much applicable. Somewhere it might be there, but not very much we see. One of the places where you might have come across that the CIT appeals, or the officer who has searched you, or he had passed an assessment order or the appellate order, he has been elevated as a judge or as a member of the ITAT, and your matter is before him. Then if you see and they will inform you, then he will say, no, I will not hear this matter. Normally the officers who have been elevated from the department and they have dealt in your case somewhere, then they try to rescue themselves and say, we will not appear. So there is an element of bias which might be involved, and therefore that is one of the reasons why they rescue themselves. In search matters, if the officers are in DBI, they specifically ask when your search was there, which unit was there, oh I was there, I might be a party somewhere in that, so I will try to avoid taking up that matter. So this is something which is called, this bias is basically an interest, and it is not to be correlated with favor. So it is not that some favor you have received and therefore it is an interest. That interest may be of wide variety, maybe personal interest, maybe pecuniary interest, maybe official interest, so on and so forth. And that famous case now that recently was going on in the Supreme Court about the judgment, or the judge's appointment was there, and the judges themselves were hearing the matter on them. So there this question was raised that you are hearing a matter regarding the appointment of collegium, all that issues were there, and this point was raised there that you are deciding your own matter, and there they say that in this situation everyone is interested in the matter, so you cannot bring this particular issue here. Certainly I am also interested, and he is also, and you, the petitioner himself, is interested. The counsels who are there, they are interested. So it is a larger public interest, and you cannot raise this plea unless you find some personal element involved in it. So it has its limitation. Just for knowledge sake, I will just deal with one or two aspects of this. In DRP earlier, now the provision has earlier in DRP the commissioner, jurisdictional commissioners were appointed, and there the plea were raised that the jurisdictional commissioner should not be a part of the DRP committee, and that the Uttarakhand High Court has also upheld. Similarly, the same officer cannot decide the appeal against the order passed by him as an inferior authority. Though it is not in context of income tax proceedings, Mohammed Chand versus State of UP, but this is the point what I was trying to explain to you earlier. So here, as I said, that bias can be any form: personal bias, pecuniary bias, subject matter bias, departmental bias. So these are the few elements, the features of bias which are there. Yes.
In the same paragraph, the second paragraph, the third paragraph,
Yeah.
page number 14.
You okay?
The second sentence, principals may be excluded by statute So, could you just elaborate?
Yeah, principles may be excluded the statute so that.
Just say which principle are they referring to? Just biasness
No,
principles?
no, the principle of natural justice. So sometimes statute specifically may exclude it for certain reasons. So if the statute specifically provides for exclusion of certain elements, for example, personal hearing. So the statute may say that you may file your reply or you may file, but personal hearing may not be granted or something like that, or may restrict your argument. For example, under the civil law, there the proceedings are very different. You file a reply, there will be a counter reply and rejoinder, etc.
So this is in connection with opportunity of being heard.
Opportunity.
Not in connection with biasness, because this is getting covered in the biasness.
Okay. So that might be, yeah, correct. So it is in that concept that a principle cannot be applied randomly everywhere. If the statute wants it to be excluded with some special reasons, they may do so. But unless it is not being done, it is always an elementary thing, that a mandatory thing, that this principle has to be applied everywhere and it should not be excluded.
Ajay,
Yeah.
can the statute exclude right to appeal?
There are certain provisions where, for example, 179 order, there is no right to appeal. 264 orders, there are no right to appeal. There are so many orders which are passed. There is
the principle of natural justice.
See, whenever this right to appeal has not been provided, it doesn't mean that the principle of natural justice is violated. The other remedies, there cannot be a wrong without a remedy. This is a saying in law, that there cannot be a wrong without a remedy. If there is something wrong has been done, there has to be a remedy. So the remedy is to go to the court by a writ. For example, 179 order is passed. What is the remedy? There is no appeal provided to you. What you can do, you can challenge it in the court of law. 148. What can you do?
The statute itself to say that it is not providing the right of appeal.
No. The right of appeal is not a fundamental right. It is provided to you by a statute.
Article 21 as the principle of natural justice.
No, it will not fall within the principle of natural justice or your fundamental rights. So your fundamental, don't confuse your fundamental rights. It is very different and very sacred. You cannot compare fundamental rights with the right of appeal. One of the basic principles under the appellate proceedings, if you will see, that right of appeal is a creature of a statute. If the statute doesn't provide it, you don't have a right. It doesn't mean that the statute itself is ultra vires or the statute is inconsistent with the constitution.
You can say that the due process is not followed, so I go on a writ.
So once the due process is not followed, you have no other remedy left, and therefore you file a writ under Article 226, wherein if you must have seen any writ, then there are clauses in which you have to make an avertment stating that why you are coming here. And one of the reasons what we give is that either we have exhausted the other remedies, or there are no other remedies which have been provided, and therefore you are approaching the honourable court under Article 226. So this is a avertment which we are required to make that. You also have to state that we have no applications are pending anywhere, or we have not filed any other writ in some other court or some other authority somewhere. So all that avertments have to be made. But certainly those two are very different.
But CIT appeals is always a departmental bias. How does that fit into this natural justice?
Interesting question. Probably I don't have an answer to this. This is as per the statute. It has been provided that the CIT appeals will be appointed by the CBDT, by the board. Though they are one of the functionaries of department, but when they are sitting as an appellate authority, they are required to function in an unbiased manner. So if you want to allege that they are biased, it is you who have to prove that they are biased.
But they are part of the department and they are answerable to your chief.
Yes, that's what I say.
They can be not biased.
So that's what I say, that unless you are able to prove this, just merely because they are from the department and they have been appointed, as the requirement of law is that they have to be unbiased and they are doing their duty of passing the order without being biased. So unless you are able to show that something, maybe in a loose talk they might be telling you that no pressure is there, I cannot do, but that cannot help you to make out that there is a case of bias. So bias, when you ever allege, it is a more an allegation on somebody. So you have to be very careful when you are making this allegation against any particular authority. I appreciate and understand your point, which is practically it is there, but the hierarchy of the appellate authority which has been provided under the statute, one has to follow that.
In fact, I think it's a second innings for the assessment. Because it tries to
Maybe the problem is not with the institution, the problem is with the person, individual. So really this cannot be brought in.
Friends, we will not take any questions, otherwise we will not be able to finish the other portion of the So till 1:45 we say, but we will not be taking any questions further. I request you to go down.
I will just take down hurriedly in few decisions which I have not covered in my talk. So and thereafter I will go to the other topic. See, there is about the principal and show cause notice. There is a decision of Vodafone wherein the assessing officer had issued the notice providing less than 24 hours to the assessee to provide with the details. And when this matter was taken up before the court, they have said that when you provide a show cause notice, you should provide also along with the show cause notice, there is a requirement, a reasonable opportunity. What do you mean by reasonable opportunity? You cannot issue a notice and tomorrow you come and answer me. No, this is not a reasonable opportunity. Reasonable opportunity means you should give me a sufficient time to meet with that requirement. Many times when we challenge this, what happens in the fag end of the assessment? The assessing officer asks for bring confirmation of 10 parties which are showing loan in your books. You cannot in last moment in 3 days get the loan confirmation. And you are not able to, he makes the addition. When we go in appellate authority, he takes this plea that see the notice which was issued was at the fag end of the assessment. And you cannot give me 3 days or 4 days to get a loan confirmation of 10 parties which might be spread all across the country. I cannot get all these things and provide. So when you say a fair hearing, a fair opportunity, it should be a reasonable opportunity to meet your case. You cannot provide that 1 day or 2 days to provide it cannot be said to be a reasonable opportunity. So undue haste, so assessing officer acting in an undue haste in passing the order. Now this was in context to 148 proceedings. The requirement of 148 is that once you pass an objection under the objection of the assessee is raised and he passes an order, he has to wait for a period of 4 weeks before he before he passes some order. He has to wait for 4 weeks before he passes an assessment order. But many times it happens that they know that the assessee is going to approach the court. They immediately after disposing of the objection, they try to pass an order. In such a situation, the court has come to the rescue and said no. Once there is a law laid down by the courts that you have to wait for 4 weeks and thereafter you have to proceed with the assessment. You cannot do in undue haste and try to pass an order, thereby trying to take away the right which the assessee has to approach the court by way of a writ. So court had come to the rescue of the assessee. There is one interesting decision on this point of Bayer Material Science. It is available on ITAT online, where the Bombay High Court has said that once you have not complied with the requirement of disposal of objection, the order is the proceedings are bad in law. Earlier, what used to happen whenever this objection used to not be disposed of, they used to restore the matter back to the assessing officer for passing a fresh order. So it used to be a second round of litigation. But this is one order of Bayer Material Science of Bombay High Court, which is available on ITAT online, where the courts had come heavily on the department and they had squashed the whole reassessment proceeding itself. This is something about 127 cases where power of transfer of cases are there. There also the courts have said that you should provide an opportunity of hearing before you transfer a case or transfer to some other order. So more or less I have covered most of the aspects whatever I wanted to cover. With this I would like to go on the next topic. We have 15 minutes. I will just broadly deal with the principle, because most of the principles what you might have heard in the earlier sessions are applicable here also, subject to some minor changes here or there. Subject to that, I will just explain this interpretation of deeds and documents. See, whenever one of the basic principles while reading any document, any statement, any judgment is that you read the whole document completely before coming to any conclusion. You can't read the title of the document and decide, yes, this document is what the title says. A very glaring example which I can give is a development agreement. Most of the development agreement, the title is development agreement, but you will read inside the document, you will find that it is nothing but a sale. He is transferring everything. The power of attorney is also given, the possession is there, is also given. Might be the consideration has changed by way of some partly in cash and partly by way of a flats or the constructed area which will come in future. But otherwise, there is nothing such sort of a development agreement. Similarly, joint development agreement. Name is given, joint development agreement. But you will see the document, the owner is doing nothing. He is just waiting when the construction will be complete and I will get my portion of constructed area. Can it be said that he is a joint developer? Now, why this is important? Normally, a document, if you go to a civil lawyer, he will draft and you will tell that this I and he are entering into this type of arrangement. You draft, he will draft and give you. The problem arises under the different laws, if you applicable. If you are now claiming under 80 10, one of the questions there arises, the dispute was there about the developer and owner who will be entitled to claim. Now, if you are saying that I am a developer, I am one of the co-developer and I am also entitled to claim this deduction, you have to prove that you are a party in the development. This is one example I am just giving an example. So, you cannot just say that yes, I have entered in the agreement, the title of the document is joint development. So, this document really means a joint development. Another example I will give you. Many times people say it is a gift deed. This property will be transferred to my friend after my death. The document title is gift deed. Actually what it is? A will. So we have to understand what many times we gift, but we restrict the right of the person to whom we are gifting to transfer or alienate that particular property. So can it be that I have really transferred him? No, I have given him a right for a particular time, but I have not transferred that document. So one of the basic and fundamental principle is that don't decide by reading the title, but you read the whole document. And that is what is the duty of the court also while interpreting the document. One of the principles you must have heard yesterday as well as today is that whenever you want to interpret a provision, you have to find out what is the intention of the legislature. The same principle is applicable here also. Here you have to find out the intention of the parties which are coming, who have signed that, executed that document. So really the income tax department cannot sit over on the head of those parties and say no. Whoever you have entered between the two parties, this is not the transaction. How I have understood that agreement, this is what the transaction. You cannot do it. This problem will now come when GAR provisions will come. Because they have now focused that if there is a tax angle involved in this, then I will invoke GAR. And the question will be, earlier the dispute used to be an evasion of tax and this. Now it is form and substance. So if the substance of your transaction, your agreement is to avoid taxation, or you are able to save some taxes, they will invoke GAR. And then the provision you satisfy the commissioner. So, and this GAR provision is not only applicable to India, it will be applied to your domestic transactions also. So you have to be careful now that anywhere there is some tax saving clause Or the officer in his mind say, no, no, you have entered only with this intention. Then they will apply that provision and the consequences will follow. So, but to counter that, it is always, and how the courts will look into this provision, we don't know, because lot of discretionary power are given to the authority. And it will be a lot of grey area and lot of litigation will come. And you all will be occupied with lot of work for the coming next, once these provisions come, you will get good. So this whole course what you are attending will be very much useful in those type of matter. You will got lot of work for next 5-10 years, you will be occupied with all this thing. So what the courts have said, that you see the intention of the parties. You don't just read 1 or 2 paragraphs and try to come to some conclusion. So read the whole intention, why they have entered, what was the situation. Over a period of time, that things are changing, people have come with new concepts of doing business. There are new agreements which are formed, which you have never heard of. Structural agreements are there, where the structure is given, but the base is not given. So if the base is removed, the building is in air. So like that, agreements are there. It is given, but you don't have right to transfer. So different sort of mind is, and people get new types of agreement which is never unheard, nor in English law, nor in Indian law. But these types of agreements are entered. So really what has to be seen is the real intention behind it, what is the purpose for which it has to be met, and thereafter one has to follow. The basic rule of interpretation what applies there has to be applied here. There are some important aspects in any document what you see, and that is the recital. The documents have the first few paragraphs is the recitals. The recital really gives you an insight, the history of the document or the transaction and purpose of entering into that document. So whenever you are drafting or reading this, you have to be very careful while putting the recital, because that is the main soul of that document. How this transaction has come into it and why, what is the purpose for entering this document. One more rule of interpretation is that many times there is an ambiguity in paragraph. We all, drafting is a skill, and over a period of time it gets sharpened. But nowadays if you will see, and whenever your document is prepared by solicitor, any simple leave and license document, it runs into big pages. So there are so many things which are mentioned, and there is quite possibility that there are 2 paragraphs which are contrary to each other. Quite possible. At one paragraph you are saying something, and the end, by the time you have forgotten what you had written in the first page, there is something else. What to do in such a situation? The court says in such a situation, the last paragraph what you have written has to be followed. Why? Because that is what you have really intended. But this principle will not apply in the case of a will. Why? If I have said that in the first paragraph this mobile has to be given to him, in the last paragraph again I cannot give it to somebody else, because it has already been disposed. So while interpreting a will, it is exactly vice versa. So exactly why. So these are the few things which has to be kept in mind when you are reading or interpreting a document. You are interpreting a business agreement, you are interpreting something which is for transfer of property, you are interpreting a conduct of 2 businessmen when they are coming together, has to be kept in forefront of your mind when you are interpreting that document. Otherwise it will go haywire. So all this aspect has to be, the principle remains more or less same at times. One more aspect is the important, is that every contract, every agreement has some essence in it, some important element into it. For example, time. If I have asked for delivery of this bottle, I have mentioned that you will deliver me at 12 on this Saturday. So what is the essence of this contract? Then time is the essence of this contract. Tomorrow if I want to cancel this contract and matter goes in arbitration or some dispute, somebody will see what is the essence. The essence is the time. If the time it was not being delivered, the contract is to be cancelled. So if there is a dispute when this contract is to be cancelled, when it has to be completed, you have to find out what is the essence of the contract. In the case of a partnership deed, normally we have read and understood that we have to provide when the partnership will get over, on death, on completion of the work, or some time frame. So similar thing in every other contract, you have to try to find out what is the essence, what is the main soul and substance. When you are drafting an agreement, you should also keep in mind the liabilities of each party and how it will be dealt with it. So that clause also has to be very clear and very specific. For example, in a leave and license, if on the expiry of the time, what if I don't give a possession? At the same time, you will know that this interest and everything will be liable. At the same time, you should always take into consideration what if the licensor doesn't return the deposit, what will be the situation. So these are the few situations which you have to curl out in your agreement. This I am just giving you an example of similarly other type of agreement. You have to curl out all these factors while making a right of preemption. When you are entering into a family arrangement, normally this is a big plot of land having 4 to 5 family members to divide it. But one of the important factors you have to keep, if this is a plot of land, maybe he is my brother and today we have partition, but for future, I don't want that my neighbor should be somebody else. So I put a preemption clause that tomorrow you want to sell it, but you ask me first. You give me the right to purchase your property first at the market rate. So you have to think from that. Whenever you are entering into an agreement, HUA, family arrangement, partition deed, or even if a partnership deed is there, somewhere the property is involved, you have to put this right of preemption in. Arbitration. Now there is a change. People don't want to go to the courts and always a standard arbitration clause are there. But if you are entering a contract with an MNC, a foreign company, where you want the arbitration to be situated, you have to specify jurisdiction of the court. You have to specify cancellation clause. See, development agreement and all this we talk and we say no, it is not a sale, it is not a transfer. But the whole agreement, if you will read, you will never find any clause whereby the contract can be terminated. And then you say no, it is not transfer. If it is not a transfer, there should have been a clause where there should be a termination clause. There has to be a clause whereby it could be said that this agreement will be cancelled upon happening of some event. If it is not there, it is what? It is nothing but a straightforward transfer. Chaturbhuj Dwarkadas is the case which gives a right example of development agreement. So these are the few aspects which you can keep in mind when you are drafting. One of the most important aspects is that you should hear the client first what he wants, really what his transaction. Many a times clients come that I want to make this agreement and after the meeting is over I understand no, he actually wants something else. So it is very important to understand the intention of the party, why they want to enter in this transaction and what really they want out of this agreement which they have to make. With this, I think so I have tried to cover some important aspects of this topic also. If any queries are there, I will be happy and glad to take it. Otherwise, thank you for giving me your patient hearing. I hope I have
Any questions during one of those?
Yes, question.
Yeah, before the citation that
I will give you in the next to this